My name is Bridget Johnson, and I'm the Director of Business Development and Partnerships for ChIPs. And I'm joined here today with our moderator, Shelley Armitage. And Shelley is the Director of Services and Solutions for UnitedLex. Just as a bit of housekeeping, we would like to invite you to put your questions in the Q&A, which you can see at the bottom of your screen. And Shelley will be moderating those questions for you. I am now going to turn this over to Shelley, who will introduce herself, and she'll also be introducing her panelists. Thanks so much.
Shelley, we can't hear you.
Sorry about that. Good morning. I'm Shelley Armitage. I'm the Director of IP Services and Solutions at UnitedLex. Thrilled to be here with you guys today. I come to this space with about 14 years of experience. My expertise is in patent search and analytics. I worked at Innography when it was a startup evangelizing IP business intelligence to people when it was in the early days when people were doing a lot of heavy lifting manually. I've worked at Clarivate and CPA Global, and in those roles working with some of the largest companies in the world, helping them use search tools for the business of supporting IP. I am so excited to be here today with this incredible panel of women. They are all passionate about the subject at hand. Sarah Foley is the founder of Foley IP. She comes to this discussion with over 17 years experience. She has worked with small and large clients, many that you know. Her firm focuses primarily around transactional IP. About 90% of the work that you do, Sarah, is around prep and pros, correct? So you know a lot about this subject. From the UnitedLex side, my colleague Gurpreet Kaur is with us. We call her GP, so if I call her by that term, you know who I'm talking about. GP is one of the best in the business. I have worked with many people over the years, and I'm thrilled to have her as a partner. She is a software engineer by trade, and she leads our engineering research practice at UnitedLex. So she has done thousands and thousands of patentability, FTO searches, and everything under the sun. So she's going to be able to leverage her expertise. And she has worked with corporates and law firms. And then last but not least, we have Palak Shah. Palak is a senior IP counsel with Uber. She comes from, she has a computer engineering background, worked at Chicardi and Bacon for years as a litigator. So when you're looking at this space, prosecution and enforcement can go hand in hand. Palak is coming to us with a little bit of a different lens with her litigation experience. So we have today IP practitioners, we have outside counsel, we have inside counsel, and we have GP, who is the person that does the work on behalf of all of our clients. So we're thrilled to have this incredible panel today to lead the discussion. So the topic of our conversation today, and would you mind moving to the next slide? Thank you so much, is prosecution. It is not, and how to use research to support it. We all know that this is not a one and done sort of exercise. It is a very nuanced discussion, and when you're thinking about your searching and your strategy, there are a lot of factors that go into it. You want to come out the other end with rejection-proof filings. You want to be able to have, and thinking about the enforcement side of it, there are a lot of components that go into your strategy. So starting at the beginning, ladies, when you have a particular client or when you're looking to support a particular idea, what's your process for selecting what is the right time and what are the factors that go into that decision? Sarah, why don't we start with you?
Okay, thanks, Shelley. I think the opening caveat on that, when do you search, is really not a one-size-fits-all approach. It's going to be dependent on who your client is, what the case or technology is before you, and really what the goal is. And so one of the first questions is, why are you searching? And what's the point of the search, or what's the goal of the search that you have in mind? For some clients, that can be, like you mentioned, to have an anticipation of what might come up in prosecution. And so to be able to have more compact prosecution, or to know where to narrow the scope of your claims so that you can advance in prosecution more quickly. But there could be a lot of other reasons for searching as well, such as like knowing the landscape of what's out there for product development, or being aware of what else is out there so that you're not infringing with the product that you're bringing to market. So it really does depend on why the client wants the search, and that can also inform when we search. In the patent side, I'll just quickly mention, when we're thinking pre-filing, sometimes it's a decision of, do we want to search before and know what's out there and then have the duty of disclosure to requirement that we have to meet, or do we want to file first and see what the examiner comes up with and use search at a later point in time as something to leverage. So there's a lot of different factors, and it really is case by case that you make that decision.
Yeah.
Sarah, when you're looking at different size clients, does that make a difference in how you're approaching it, or it really is connecting back to that same question of why?
Did you ask the size of the client?
Yeah, does it make a difference? I know you work with smaller companies.
It can. A lot of times larger corporate clients will drive that decision for you. So they may have an internal policy about when they search and how, and that informs the conversation at that point. But with a smaller client, I do tend to recommend a search before filing in terms of patent prosecution, just because for smaller clients, a lot of times the patent application process represents a bigger investment relative to, their overall company or business than it may for a corporate entity. And so having that search first, which is a relatively smaller investment, can really help inform the client which direction to take, and especially smaller clients who might be more budget conscious, can use those search results to decide how they want to move forward.
Mr. Pollock, you had a comment?
Yeah, I really wanted to echo everything that Sarah said, coming from it, from a litigation perspective, it really kind of is the same, kind of thought process, right? In the sense that we have to tailor our search to what we need, from a litigation perspective, enforcement, right? When we have a patent asserted against us, it's, I don't want to say always, that's a tricky word, but we're probably going to do a prior art search. Just to understand the landscape, unless we really think we have something on point, but I'm hard pressed to find a situation where we wouldn't. And to Sarah's comment about really understanding what the business needs, I think that duty of disclosure really weighs heavily, right? Sometimes it may be an invention that we just want to have a filing on, right? Even regardless of kind of how crowded the space is, it's really important to our business, and there is value even in having a filing that maybe doesn't make it all the way through. I mean, I think there's pros and cons to that, right? But being able to paint that story of, we thought of it in this time, and we have a filing, we took it seriously enough to have a filing. And sometimes a search can weigh against that. It feels like you're handing the ammunition over to the examiner and saying, look at all this stuff that's already in this space. So I think I think on the pre-filing, there's definitely advantage, it's kind of a cost benefit analysis. I think even in the instance of maybe you've gotten some sort of demand letter, or, that can be useful too, is having, I think there's different types of searches, which we'll talk about too, but there's sort of a tailoring of, do you want to understand the landscape? maybe it's someone sent you a letter and it hasn't been filed as a litigation. Maybe that makes sense. That's a time for you to say, maybe we can run a quick preliminary search and use that as leverage in a negotiation. So there's really a lot of strategic points that you have to just think about cost benefit analysis. And in litigation, that's always going to be damages. So if it's something that's a letter and you can kind of see a big dollar sign that's assigned to it, maybe that makes sense to run a search at that point and get some preliminary results and use that in a negotiation.
GP, do you have any comments? I know there are lots of different types of searches that you can conduct in certain points of this process, depending on as Sarah said, the why you're doing the searches.
Absolutely, Shelley. So, as both Sarah and Palak mentioned, what matters the most is the objective of the search. Why do we want the search? Whether there is a demand letter, as Palak said, like a cease and desist letter or something which is on the table, or, it's an initial idea, an initial invention which is submitted by inventor. How crucial that invention is, do we have multiple such inventions coming in from inventors, or maybe handful of such inventions? So I would say the volume will also kind of impact which type of search we'll do, and how we kind of move forward from there. So for example, for some of the high filing corporates, if there are, let's say, hundreds of inventions which are coming in every week, it doesn't make sense for us to propose a patentability search for all those hundreds of inventions. So maybe we do an initial pass with some let's say AI assisted type of search, and with predetermined thresholds, and then we filter out inventions which are not worthy of committee's time, not worthy of attorney time, and only let through of inventions which are of high quality. So that can be another way, and then we do the patentability later. And then again, to Palak's point, who has sent that letter, that demand letter, that cease and desist letter, what to kind of gauge the merit of that, a preliminary prior art or invalidity type of search can be conducted. And then it becomes little iterative in nature, where we have initial results, some preliminary results, we discuss with the counsel, and then we kind of move forward and do like a full-blown knockout type of search, which sometimes can also lead to kind of foreign language search or native language searches on PTOs and stuff like that, depending on what the stakes are. So yeah, I mean, all those parameters would kind of determine which search to do, and when to do it, and what are the key factors which we should consider while taking that decision.
It makes sense. I'm in San Jose this week at the IP Executive Leadership Summit, and one of the themes that has come across in a lot of the panels is working with the business and telling a story, having your IP tell the story and connecting back to the business matter at hand. Palak, that's something that we talked about on our preliminary calls, is that the story and the why. Do you want to talk a little bit more about that?
Yeah, I'd love to. Thanks, Shelley. When it comes to litigation, right, it really is about the story, right? We're trying to craft a story, of course, on the defense side, right, of something that's come before what's been asserted. And so a patent search is so key to that. And it really can't be understated that search really helps give you a landscape of the art that's from that time, and or way earlier. Sometimes you kind of don't know. And a huge part of being able to tell that story is something Gurpreet has touched on, is really understanding the right type of search, right? And that kind of drives what kind of story you want to tell is going to drive the kind of search you want to do. And from a litigation perspective, what's really key is sometimes we have something that, a technology that feels pretty, run of the mill, and that's, searching shouldn't be too complicated, and we can reach out to firms that can help us do that. And then there are other instances where maybe the asserted patents have technologies that are an intersection of two different two different technologies that is really unusual or very niche. And so then we're going to tailor that. We're going to tailor our searches accordingly. Maybe we go with a crowdsourcing approach, and we can work with firms that facilitate having experts in those areas that are able to pull references. And what we find is that that can be a really fruitful way to tell the right story, right? You're really looking for that golden reference. We also chatted about there's like a level of excitement with patent searches, and when you get the report and you're kind of scanning and you're thinking, is this the one that's really gonna get us there? And that's all part of being able to ultimately go to the jury, right, and say, look at this reference, and it tells a great story, and it's from this time. Maybe it's a dissertation. Maybe it's a, kind of a system that was alive and at that time, and everybody knows about it. And you kind of just needed to find that reference or references to tell that story. So that's a huge part of it. And one other thing I think Gurpreet touched on is patent searches are really a marathon, and they're not a sprint, right? It kind of evolves over time, and that's part of the story. As you're sort of figuring out what narrative you want to tell, your search is going to track that. It's going to stay, consistent with that over time.
Sarah, do you have anything to add?
I'll jump in and add that everything Palak said is such a good mirror to how we view it on the transactional side, or the pre-litigation side, if you will, because we're also trying to tell a story. And that's something that we're trying to do when we draft a patent, is tell a story of the invention to the examiner, and then, ultimately those of skill in the art that explains why this is new and novel, non-obvious, and deserves a patent grant. And the patent search is a part of telling that story. If we have searched pre-filing, and then those results are something that we've used to scope the patent filing, the claims and the description that we're putting forth. And so it's part of the story, because the examiner is going to be considering that and considering the nuanced differences, right, of the invention that we're claiming. And I think in the other regard of that story would be outside maybe the patent filing or prosecution stream, would be in clearance searches and product development, where you're going to search initially at the very beginning of a design phase, but you're going to search again. Like Palak mentioned, it is not a one and done effort. You're going to search again as development continues and before you go to market, to make sure that you're staying clear, right? So there's different types of searches, and at different points, you may need to go back and research, but search again.
GP, you're nodding a lot.
Yeah, I think Sarah touched some very beautiful points, where the story can go in a different direction. So, I have seen some of the clients taking a direction where, after doing an initial pre-filing type of search, they totally don't want to file, and they may want to go the defensive publication route, as opposed to filing a patent. So I think that's also another dimension to it. I would say how the results of patentability or a pre-filing search can be read to take a decision whether to file or not file, completely let go, or at least do a defensive publication, in that regard. But at the same time, we obviously see that even when there are, one or two type of bang on prior art, still, because of the business objectives that are associated with the particular product where this invention is coming from, of course the patenting is still move forward with, and then we see multiple patent applications kind of filed to protect that product, because that importance, or if there is a launch which is kind of queued in the next few months or next few years, then it kind of vetoes everything else. And I'm sure I see Palak nodding now, and I'm sure she faces a lot of these situations where and it's very surprising for us, when we submit our search results and we see, these patents were still filed and, got granted, even, when the kind of art we reported was very close. I mean, it was almost the same. So I'm sure both Palak and Sarah will have their own perspectives on, how they kind of circumvent the prior art, or how the business importance kind of plays in, in this decision.
So let's move on and talk about optimizing your process. We talked a little bit about different tactics, but how can your search strategy help optimize your overall process? Sarah, do you want to take that one?
Sure, I can start. So, the search, we've talked a lot about why you might search. And I think one of the things to do to optimize the search, if you decide that it's the time for it, is to really think through the information that you're using to search. And if you're going to use a search firm, like we work with UnitedLex, so oftentimes for these searches, thinking through how we provide the invention details to the search firm, the background, the problem solution statement, and the key features. And something that I think would be great to have some back and forth here with Pollock and Gurpreet on is that on the outside counsel side, we often think of it from a standpoint of, I want to make sure we really focus the search on the key features of the invention so that we get relevant results. Like, I don't want to get this huge, broad bucket of results. I really want relevant results to know if there's space. And a lot of times that's because the invention is in a nuanced improvement or something, and we want to really make sure that we understand if we have clear space to move forward. But we were talking on the preliminary call, Gurpreet, about how sometimes that may not be getting us the results that we want, if you want to pick up on that.
Yeah, absolutely. So yeah, I mean, when we get a request for a patentability search or a pre-filing or any other type of search, sometimes we get a draft claim, sometimes we get like a 50-pager disclosure, or sometimes, it's just a paragraph. So for us, it's really important to kind of understand what's the problem statement, how is the invention trying to solve the problem, and then, to be able to give the results which are very focused on the exact invention, but at the same time, if there are any results which lie at the periphery, we also want to be able to give that, so that you have all the ammunition with you to kind of draft the best possible claim, and hopefully the broadest possible claim, which may help down the line. So yeah, I mean, we often face this, I would say, push and pull, like a healthy push and pull with attorneys when we get these requests, and how much narrow we should go in the search, and do we need to be broad, or if it's an independent claim which has already been drafted, then sometimes that kind of puts some boundaries on our search, and we are not able to cast a net which ideally we would have wanted to cast if this was just a disclosure. And that sometimes kind of limits us in terms of what results we can provide you.
Gurpreet, is sometimes too much information also not helpful? Like, I've wondered, you mentioned sometimes you get a 50-page, maybe provisional application
Yes.
For a post-filing search. Is that too much?
Sometimes it is too much. I would say provisional applications are still okay, but sometimes, I mean, we know how passionate inventors are, right? And they will create PPTs and spreadsheets, or sometimes there are algorithms as well. So in those situations, we need more help from you, from outside counsel, so that we know what exactly is the invention, because sometimes we see 2 to 3 inventions there, and we go back to you and we ask for more guidance, as to how to kind of structure the search, or maybe split it into 2 to 3 different inventions and then kind of focus further.
I'm going to jump in real quick. When as Sarah mentioned, we talked about this on an earlier call, and I was really actually shocked by Gurpreet's response. I really was. I thought, I tend to think, and I think maybe a lot of attorneys do, that that an IP practitioner is less is more, right? And so the more we focus it, we're, especially from the enforcement, you know, when things are enforced against us or asserted against us, we're very focused, right, on a limitation. We're kind of zeroing in and making sure that if this is the key claim and limitation, that's really covered. But I really was surprised by Gurpreet's response, and I think it's really eye-opening, right? Is that it kind of comes back to the same discussion point we've had so far, really, is what's the objective you're going after? And truly, it's not, I mean, it is the claim, but it's also part of the story. And the story is, what is the problem statement the invention is trying to solve or overcome? And so I think that really just speaks to how important that is throughout the process. And if you're running a patent search, I don't think it really can't be overstated that it benefits you to sit down and really understand what is it that we're trying to go after. And I think Gurpreet's approach of figuring out what that problem statement is and maybe even writing it down and saying, this is the problem statement, this is what we're trying to either achieve, you know, to have come through the patent office, or we're trying to sort of take down and find some prior art. And that's really a guiding principle. And sometimes I think you might find that problem statement is shifting and changing, but the clearer you are on that at the outset, the better results you're going to get at the end. So it's worth the investment in time and effort to really solidify that as much as you can upfront.
100%.
Yeah. And, you know, I'll just jump in and mention, I think this conversation has been focused on how you might provide the relevant search terms for a firm to do the search for you and provide results. But there could be situations where, as an attorney, you're going to do the search yourself. I sometimes talk to students in the patent clinic at law school, and they're working with pro se or pro bono clients, and so they're going to be doing the searching on their own. And what I tell them to do to optimize their search is to really think very carefully about the words that they're using, the language that they're using, because inventors tend to get very focused on the terminology that is comfortable to them, or the terminology that maybe they use internally as a team. And that terminology can really trip you up if you don't first unpack what it means to them, and then think through the ways that it could be phrased differently or termed differently in a broader sense in order to capture that relevant art, which could be out there, and a patent examiner is going to find it because he's going to read, you know, this reference onto it, but it uses different terminology. So I don't know, Gurpreet, if you have a comment on the terminology and the language that we use, but I know when we're searching ourselves, that's something that I like to think through.
Right. So, Sarah, I mean, I, as a searcher, and when I talk to the team also, we like to spend a lot of time initially, in terms of writing that statement of invention. I think that was where Palak was also kind of leaning towards, we understand the background, we understand the invention. So if we are able to describe that invention in a single statement, write that statement of invention, and then be able to pull keywords or terms or different type of terminology, which sometimes it's also very geography specific. There are some terms which are used in North America, but totally different terms for the same thing are used in Asia, for example. So that becomes really important for us. So we want to spend a lot of time and not rush towards finding results quickly. Rather, spend some time in terms of having the right terms in place, having the right classification codes in place, or what type of parameters, what type of bibliographic information we are going to use when we are going to start the search on the databases. So we like to spend a lot of time there, as opposed to rushing with search results, and being able to identify all these parameters. And sometimes it also kind of helps us where to search, as in for some inventions, maybe YouTube is a great source to identify prior art as opposed to patent literature. Or sometimes we really need to go through the standards and kind of dig the prior art that exists in those standard documents, or the back and forth, the meeting notes from the standards when it comes to telecom and those type of technologies. Yeah.
I know I'm not the moderator, so sorry, Shelley, to jump in on this. I have Gurpreet, we have you here, and I'm very curious your thoughts on this. So, I think, you know, with prosecution, it's a little more current, right? It's with the times. What's the landscape now? What are, you know, what's kind of happened in the past, but not necessarily like a much older time frame. I think in litigation, we're often finding these patents are sometimes they're expired, right? And so we're looking back 20 years, we're looking 10, 15 years, and it's challenging because obviously as the further back you go, the less digitized things are. And so that makes it a little more challenging. So one thing we try to do is get a little creative and sort of go back to ourselves 10 years ago and look for a really common sense example. You know, oh, you know, they used to adjust pricing for a flight seat based on the time and the day, and, you know, maybe you as the user. And so that's not new. And so sometimes we use that strategy to then tell our search firms, you know, what do you think of this feature that I know existed 10, 15 years ago? Is there art on that? Is that helpful for you on the search end? Is that, you know, give you kind of a hook to get started, or sometimes is it not as helpful as we think it is?
It's totally helpful, but like if we get any inputs like that, if there is any initial research, you know, that you've done, that the attorney has done, and if we get that, at least, you know, that kind of gives us an initial direction and a head start. And yeah, I mean, you know, there are patents that come for invalidity sometimes, which are really dated, and we have to see whether Wi-Fi existed at that time, or, you know, if they are talking about data transfer, then which technologies enable data transfer between, you know, two portable devices back then, let's say in early 2000s for that matter. So it, you know, we try to develop the terminology or terms like Sarah was mentioning, considering these things when it comes to litigation and invalidity or validity, or sometimes even, you know, during the rebuttals that may come during litigation. So as you said, you know, have to kind of move ourselves a bit behind on the timeline and then think, read some art. You know, sometimes we put date restrictions which are, you know, only like a 2 to 5 year window when this patent was filed, you know, maybe plus minus 2 years, and then try to understand how the art was kind of drafted at that time and what type of terms were used.
So, Pollock, when we were talking about the subject, you mentioned your thought that litigation and prosecution are two sides of the same coin, and that you're always thinking about one when you're thinking about the other. How is searching leverage in the process of protection, whether you're looking at it from an offensive or defensive perspective?
Yeah, I think, yeah, like we've talked about, I think the strategy, I mean, obviously there's differences, right? Sometimes it's a time period difference with litigation versus prosecution in terms of the times that you're searching, but it really is similar in strategy. I think you're sometimes thinking of, I think for me, the key is really the kind of the breadth of the search and the timing of the search, right? And prosecution and litigation are really can have different timelines. You know, maybe in prosecution, you have a little bit more time before this technology is going to be rolled out. And so maybe that leaves you more time for a thorough search to see if it's a crowded space. On the flip side, if it's, you know, sometimes you get, hey, this is coming out next week and we know we need to file something and we want to know how crowded it is. Then we can sort of tailor our search to be more preliminary. And I think really that's the same for litigation, right? With litigation, it's a little bit more of a long game. You're not going to get a complaint and then you need to know all of the valid, you know, all of the prior art that's going to be out there in a week. And so you get that breadth of search. And it's over time, and it gives you that depth as well. And so I think it really is informative, right? When at Uber we all get staffed on litigation, and we also have a prosecution portfolio, and so you find yourself really thinking with some of, you know, these newer applications, what is this space like, and what do we think could be asserted against you, or could be used to invalidate it. And sometimes I think, to be honest, it can also be really tough. There's pros and cons to that. I think you can almost psych yourself out, right? When you start to play both sides of the game. In litigation, you're always looking for the story, right? And sometimes I think when I go back to prosecution, I sort of psych myself out and say, I could see someone making a story for something else, and it sort of makes you doubt yourself. But maybe that's what makes for a higher quality patent. It really forces you to think. I know Sarah had kind of touched on that, and I think that's totally true in our preliminary call, right? That it really gives you that checks and balances. It's not an automatic knee jerk, I'm always going to do one thing or another. You have to really think, again, to Sarah's point about one size does not fit all. It really makes you tailor to what's your objective and what strategy do I need. And it's a learning process. I think sometimes you'll find, oh, I wish I had done something a little broader, or maybe I wish I'd done something quick that wasn't as broad. And it's sort of I don't want to say trial and error, but you start to get a groove and a feeling for, when I get this type of letter or complaint, this is the kind of approach I want to take, or if this is the invention that I want to protect, this is the kind of approach I want to take to really protect it as best as you can. Sarah, I would love to hear your thoughts. I know we talked about patent quality in that respect on that point.
Yeah, I think it's so, like you mentioned, litigation and prosecution, I think, inform each other in a really great way. And so when I hear from litigators about the things that killed their case, maybe it's a term in a claim or the lack of support or something else, an element of the case, it does inform how we prosecute patents on the earlier side. You know, how are we drafting, and how are we scoping our claims, and what kind of support are we putting in there? And then, of course, the law is always evolving, and what worked 10 years ago or even 5 years ago, we might not be able to get an allowance on now, or it could be invalidated now. So it's like a moving target. But I think being able to be aware of the challenges in litigation when it comes to these different things makes us better on the drafting side. And I've heard, litigators say the reverse, like remembering some of the constraints that prosecutors have when they are drafting. It makes them appreciate why a patent that comes to them may look a certain way. And going back to the search aspect of it, I think that, again, it's part of the story that you can tell on the prosecution side. If you do choose to search, maybe a patentability search before filing, like we gave our best effort to try to find what was out there. And during the prosecution, whatever the examiner cited, we did our best to distinguish over it. And so if it later does have to face litigation, I think that tells a really good story of due diligence on part of the client, that they took those steps and those measures to try to get a really good quality patent and a valid patent.
GP, do you have anything to add?
I think we heard, both the perspectives from prosecution to litigation. So yeah, I mean, when we also work with clients on litigation versus prosecution, it's always, like a balance that we try to maintain. And some clients don't want to know about too much prior art during prosecution stage, while, they are very aggressive when it comes to litigation and invalidity, type of patent searches. So yes, I mean, invalidity searches, during litigation are more demanding. We see the attorneys are also way more stricter in terms of interpretation of the claims, interpretation of the different terms, while during pre-filing, still the claims, I mean, even if we read the terms little broadly, or we report something which is not completely hitting on, but something which is closer in the same ballpark, it still works. But during litigation, that becomes a challenge. I mean, that becomes more demanding for us, working with the attorneys there.
Perfect. I'm just looking at some of the questions in the chat to see if any are appropriate to interject into our discussion, or if we should include them at the end of the meeting. We'll address those at the end of the meeting here. So shifting gears a little bit and talking about technology and how you leverage technology. Some of the panels that I've been, people that have joined late. I am in San Jose's IP Executive Leadership Summit, and there have been so many discussions around AI. Of course, it's the hot topic. Everybody wants to know how to leverage it. Should you, and the value and the risks. We had Steve Gong, who heads up IP data science and technology for Google, and he reminded us all that AI is not new. It's been around since the 70s. It's happening. It's not the evil entity, and it is going to affect our jobs in IP, and it's going to evolve in the coming years. So something to discuss on the call today is how are we leveraging it today in terms of searching, and how does it increase the efficiencies and help us gain insights? GP, do you want to start? I know in the work you do on behalf of our IP business intelligence tools have always been fueled by AI. So things are evolving and changing, but in what capacity, and how can it help us support our customers better?
Yeah, see, I mean, things have obviously changed, with AI, with machine learning, and then with Gen AI, of course, right? So we try to balance the use of artificial intelligence and machine learning during our searches, but at the same time, we are not overly relying. We need to be cognizant of the confidentiality aspects as well, especially when it comes to pre-filing type of searches. We don't really experiment a lot in terms of using AI or machine learning, and we go deeper, with our database subscriptions as well, and how they are using the queries that we are putting in, how are they kind of learning, and we try if we can get that kind of hosted internally at UnitedLex servers as opposed to using someone else's servers, because the kind of confidentiality agreements that we also have with clients, and then clients, of course, since ChatGPT, we've received these emails from client, notifications from clients that we should definitely not put invention disclosures on ChatGPT. I'm sure, Sarah is going to add more on that, but yeah, where we use AI or machine learning is to kind of optimize, to curate a maybe smaller data set, or to create a data set which is more focused, and then kind of, supplement that with manual analysis. But another area, where we use artificial intelligence or machine learning is when we have to compare patent portfolios in a same technology, or, we are doing a search where, let's say, we have to do that search back in time, like an invalidity, validity type of search. And we try to compare patent portfolios of, let's say, two competitors, what they had at that time, and then what type of findings we can get, how we can use some of those findings to get better prior art. If not better prior art, then, to identify search parameters that we can use to get, eventually a golden prior art, as I guess Palak was using that word. That's the overall objective, but we don't overly rely on AI, and we keep on evaluating from time to time. We don't think we are ready, we are there yet. Who knows, in the next few years we might be there. But for now, our approach is, I would say, little cautious. While we want to use the best of both the worlds, automation as well as manual, but we want to be slightly cautious with our approach.
Very much so. Sarah, you mentioned in working with your clients that this is something that you're having to advise. Do you want to talk a little bit more about that?
Yeah, whether it's whatever size client, really, it's important for us to have that conversation. We're starting to have that conversation with the inventor communities about the parameters around AI, because a lot of inventors will ask me, can I use ChatGPT to write my disclosure submission? I don't really have time. And the answer to that is no. not just from me, but a lot of times from the companies that they work for. And so we're starting to see a lot of our clients come up with, internal AI policies for their internal community, just to put some guardrails around the use of it, because while it is a great tool to leverage, and while it has been around for a really long time, some of the newer iterations of generative AI aren't in closed systems. And so there, like Gurpreet mentioned, there are some confidentiality issues. So we don't want to put novel features out into our large language models for them to learn on. But I think that there are a lot of ways in which this technology is growing and changing really fast. So it'll be interesting to see, how it's leveraged in the future for search. I know that a lot of the search tools already use aspects of it, like you mentioned, Gurpreet, but it will be interesting to see how it's used in the future. And I was thinking about this along the lines of this question. It would be really interesting to see how like multimodal LLMs might be used in the future for search against design features, because design patents are really hard to search. It's a visual and an aesthetic. And so I wonder if some of these new tools will make searches better in that space, where traditionally they've been a little bit more challenging.
It'll certainly be interesting to see how things evolve. Palak, you were nodding. Any thoughts?
Yeah, I think there's kind of a lot to unpack. I think I totally agree with what both Gurpreet and Sarah have said. One thing that Gurpreet touched on, right, is I very much think we're also in that cautious space, right, when it comes to having some automation and then some manual review. I sometimes think of, I think at Uber, it's a little more machine learning, at least on kind of for the purposes we're talking about, versus full-blown AI, right, or generative AI. But I sort of think of it as like a starter, right? It kind of gives you like a starter data set or a starter set of references or whatever you may want to call it. One thing we really leverage, I won't talk about it too much just because it's not exactly in this space, but we really use it in sort of the pre-litigation aspect of things. We have a lot of machine learning models that are trained on our portfolio. So it really knows our product spaces and what we're looking to protect in our business. And we use those models to help us identify, we're part of these risk mitigation orgs like AST. And so a lot of times AST is sending us these patents that are up for sale or for licensing. And it can be overwhelming, right? I mean, we're in a lot of spaces, but there's also a lot of other companies that are part of that organization. So we're inundated with technologies or patents that are touching on technologies that are totally irrelevant for us. And so our models really helped out, like streamline what should definitely get a look at. And of course, like Gurpreet said, it's really a starter data set. It's telling us we think these things are relevant, but we're still kind of doing a manual check to make sure that those are the, if there's other things that the model's missed. But I think it's another example of, and I think this will be true for the legal space, especially in the patent space, right? There's a lot of overlap between litigation and prosecution. And that's what I think is really interesting is AI might be able to be this middle element that's helping bring consistency between the two sides. You could see using those same models to find prior art, right, or search through things that we've used before or has shown up in other litigations that are relevant. And so there's a lot of potential there, but I think a cautious optimism, right, and being sure that you've got your client's best interest in mind. I know there's been a lot on AI, and there's kind of some ethics pieces to that too, right? So it's a challenging topic, but something you can definitely see a lot of potential on both sides of litigation and prosecution.
Yeah, very much so. I want to be cautious of our time. We've got about 10 minutes left, and we want to save some time for questions at the end. We've got some fun things that we wanted to discuss with you as well. Looking back on the conversation, is there anything that you'd like to add or take away from the discussion? How do you want people to remember your contributions and what's most important to you?
I think my takeaway would be just to remember that there's not a one-size-fits-all approach to patent search, and that it's very case specific and client specific, and you really have to understand the needs of the business, the client, and the goal for the IP to decide when and how to leverage search.
And I'll just piggyback on Sarah's comment there. I really think it's really, you should front load the time you put into, all of the things that Sarah just said. Don't just sit down for 15 minutes and jot those things down and say, oh, that's going to really take time to think about each of the things that Sarah said, right? What you're trying to achieve, what the problem statement is, all that good stuff, because that's really gonna pay off if you do that work up front, versus trying to sort of do it in the middle of search and realizing, oh, these results aren't what I wanted. And that's not because of it's because the things that the parameters I've given them to search were not as fully baked as they should have been. So I think that preparation is so key to streamlining the whole process, and sort of getting bang for your buck.
And
Yeah.
adding on to that, CP, are there, you have an opportunity to talk to hundreds of people here and share kind of your wish list. I think oftentimes the ability to understand the nuances of what you do and how can they best set you up for success. So I'd like you to maybe touch on that as well as your takeaways.
Yeah, I think both Palak and Sarah, I agree with them 100%. And when it comes to execution perspective as well, in terms of different techniques that can be used for a patent search, every search is unique, and we need to leverage different levers. We need to be able to identify all those different levers and then kind of leverage on them. Those can be, from classification codes, and now there are so many classification codes that can be used. Do we want to use inventors, assinees? Do we want to use geographies? I mean, people often, don't give that much importance to geographies, but then, from where the inventions are originating, that is really important to understand, when we are doing a pre-filing, or for that matter, a litigation search, a validity, invalidity type of search for inventions which are, very core, inventions originating from, let's say, South Korea, or inventions originating from China, Taiwan, there are inventions like that. So for them, if we try to identify prior art somewhere else, it will take a lot more time. But to be able to have that judgment skill, or to be able to use those levers again, I think that is something that I definitely want the listeners to have a takeaway. And then don't forget the good old PTO websites as well, YouTube, or we can use ChatGPT. I mean, ChatGPT can, of course, tell us competitors. They can tell us who is doing what, but then we need to take that with a pinch of salt, because it is also very creative, right? ChatGPT sometimes create things that don't really exist, right? I'm sure all of us have faced such examples as well. And keeping your eyes and ears open, I would say that's really important as a searcher. Don't really kind of give up when it comes to a litigation search, because I mean, I truly believe that I think at least 75% of the patents can be invalidated. There is that prior art that exists. You need to have that belief, and to be able to use all these levers and parameters so that you are able to uncover that one golden art that exists.
At GP, we know that you have a client that calls you Darth Vader because of your validity prowess and patent killer. So I love your nicknames. It's hilarious. Well, we just have a few minutes. We have a fun question for you, GP. What's the weirdest or craziest search you've ever conducted? I've seen some crazy things come across your desk.
Yeah, I mean, sometimes we get these crazy inventions from sometimes from individual inventors, right? And then sometimes when we are searching, it becomes really crazy with the kind of prior art that we see. So I remember one, maybe this was like close to 15 years ago. and it was an invalidity search, and we were trying to identify like how the windshield of a car is kind of connected, and the kind of connection it has, what type of rubber it uses, and what type of buffer or kind of shock mechanism it had. So we read, I mean, every patent under the sun, but we couldn't find a prior art. And guess what? We were like one of the team members who was working on this one. We were walking in a parking lot, and then we saw this car, this German car, which had that same thing. So we clicked a picture, and then we tried to identify when that car, I mean, what was the launch date, etc. But that was something which was, I would say, crazy fun. And it's really difficult when you're doing a patent search one after the other. You're doing your searches, putting your queries on databases tools, but some of these things make it interesting. Another weird one which I remember, we were trying to do a freedom to operate, like a clearance search for I guess for a retailer. And then this was related to kind of a lounger, where you can kind of relax, watch TV, or maybe take it to a beach and lie down. And I saw a prior art. So I was on a vacation, but my mind was still there. And then I saw this in a lounge in a hotel, in Dubai. And I clicked that picture and I'm sending it back to the team. We got prior arts. These are a couple that came to my mind, which were funny, crazy. I don't know if you want to look at it.
Real world. That's hilarious. Well, we do have a few questions in our Q&A. One is to Pollock. Pollock, in which situations do we normally perform FTO searches, if any, in-house or contract out?
Yeah, so I think for this question, it's a great question. It's I think this actually unfortunately kind of comes back to what Sarah was saying, right? One size does not fit all. And that's really, I think, Uber's approach. I don't think we have any sort of blanket policy of if this, then we do an FTO search. I think it's going to be very dependent on the technology that we're looking at. The one thing I do know, about Uber is we're very open to using all the tools in the toolbox, and that can be an FTO search. Obviously patents are, prior arts are all kinds of, different avenues we have or tools we have. But I can't say I really, we don't have like a firm policy. I think sometimes it just depends on the invention that's before us, or, the objective. Again, to what we've reiterated, it really just depends on the objective, and that's really going to drive when, if and when we're going to do an FTO search.
Goes back to the overall theme of strategy of the day. It's all dependent.
Yeah.
But it's been wonderful to hear all of your best practices. A question for GP. Has UnitedLex formal search procedures for different types of searches? How are these searches, how do these search procedures depend on clients and their budgets? And do you have standards for reporting search results?
Yeah, so at UnitedLex, we have formal search procedures and defined SOPs that we use for different type of search. Of course, that depends on how much budget is there, what is the turnaround time, and then, as we touched upon earlier, what is the objective that the client is trying to solve, and what is the why behind doing that search. I think that's really important, and that kind of drives the standard operating procedures that we have in place. At the same time, see, when it is like a no stone unturned type of a search, then we go full blown, and we don't shy away from sometimes calling sellers on Alibaba and asking them when did they manufacture that, or sometimes writing to research scientists or university professors and trying to understand more about an article that they have written. So I would say we need to be creative while still following the procedures that we have.
And one last question, GP. Does UnitedLex explore AI tools, including GPT for prior art searching, and is that disclosed to clients?
Yes, we do explore AI tools now. There are a lot of tools available in the market that claim to use AI. I guess all of us understand to some extent AI is a buzzword, and sometimes it is little machine learning which is happening at the background, or it is, I mean, the curation is basically in real time, which might be perceived as AI. So we keep on exploring these subscriptions or these ready-made tools which are available in the market from time to time. As far as ChatGPT is concerned, we don't use that for patentability or pre-filing searches. We use that for more of identifying search parameters and doing things at the periphery, but not during the search as such. And yes, the use of all the tools is disclosed to our clients. So any tool that we are going to touch during the search will be disclosed to our clients.
Okay, well, thank you. Well, I appreciate your active participation, ladies. It was a great conversation today. I hope to cross paths with many of the ChIPs members. I will be hopefully at your conference this year. I'm in the process of becoming a member, so I hope to have more conversations with you guys in the future. If you have any additional questions, or if UnitedLex can help you with your search and analytics, we'd love to continue the discussion. So thank you very much, and appreciate ChIPs for hosting us today.
Thank
Thanks,
you,
Shelley.
Shelley.
Thanks. Yeah, thank you for moderating. You did a great job. Thanks.
Thanks, everyone.